every Canadian, tens of millions of Canadians who were forced by this Trudeau government to sign up for this ArriveCAN app.
Point of order, Chair.
It looks like had their personal information wildly.
Hold on, Mr. Brock. I have a point of order, and go ahead, Ms. Khalid.
Thanks, Chair. I'm just questioning the relevance of Mr. Brock's questioning. I'm sure the witness is not called for the line of questioning that Mr. Brock has delved down.
Just hang on a second. In every circumstance that a point of order is made, I am consistent in my ruling. Ms. Khalid, we can beat a dead horse on this.
You heard the exchange. Some Liberal members don't care about privacy. Conservatives certainly do.
I object to
I'd
that.
like to get your
Mr. Brock.
opinion.
This Guy's Garage. Like and subscribe.
The difference between the use of these very, very powerful tools for administrative purposes within, say, a department or agency versus for investigations where they would be used on Canadians, whether with judicial authorization or the various other forms to which we've been told that they could be used.
Sure. So I think regarding use internally, I think that most of the agencies that have testified so far say we use them on our employees and we get their consent. I think that it's difficult, if not impossible, for employees to actually give informed consent in these situations, that there's an imbalance of power and there's an imbalance of knowledge. We've seen in the sessions of this committee just how difficult it is to explain what these devices are capable of. And consider if you were a junior employee and your manager says, we're going to use this device on your cell phone, you have no real alternative other than to say yes. And so I think that there's I think the use internally is quite fraught and imbalanced. In terms of its use with warrants, I think that there needs to be a step before you get to a warrant. That we should talk about necessary and proportionate. There are questions that we should ask is this technology valid to be used to begin with? And this is where privacy impact systems come in, which personally I think are useless to a degree. They basically account to self-regulation right now. And so there's no process to which agencies or ministries are obliged to go through that would forbid them from using any technology. We saw this in Scott Jones's testimony on Tuesday, that he will buy this for anybody in government who wants it. There's no standard, which is mind-blowing.
You were quoted in the CBC story as saying that you were troubled, deeply worried, I guess, by the information that I presume you were presented by the reporter about the PIAs not being done in the 13 departments. You've heard, I imagine, the testimony from the different departments. You don't in any way deny or disagree with their assessment that they're not using spyware or malware and seeking to spy on Canadians at large, correct?
I have no evidence that would point one way or the other. I haven't done that research. I've done some. I mean, procurement is a difficult sort of research to do. We work on contracts that are out there on public record. I think a lot of spyware companies sell their wares through third parties, and so that it's actually difficult research to do within government. But in the data that I've had, I haven't seen anything one way or the other, and I cannot.
No, but I mean, they've testified that they don't use it. You have nothing whatsoever to contradict that testimony, correct?
No.
No. Okay. So you have no basis to state the opposite, is what you're saying. You just don't know. You're saying that you can't be sure their testimony was truthful.
Exactly.
Okay. And with respect to data extraction technology, you have to have the device in your possession. You agree with that, right? That's not spyware or malware.
You need to have the device initially. There are hardware components to mobile reference devices that enable the creating an image from a phone. So imagine you're pulled over, you're at the border, and you're asked for your phone. It can take maybe 5 minutes to make a copy of somebody's phone. And then you have an image, just like a CD image, that can be shared between agencies, that it can be put on a USB drive, data, it becomes a portable thing.
But now you're saying that people are acting completely outside of the law and the limit of a warrant and the limit of their authority to do that. You've had no testimony that has ever shown that any of that has happened, correct?
Correct.
You have no basis to say that other than your supposition that this is hypothetically possible.
Correct. As well, I'm going on the basis of just the capabilities of these technologies and what they're advertised for. So for instance, if you look into the Celebrate marketing materials, they advertise their cloud capabilities as ways to work around warrants. that in the past you would need to get a warrant to use anybody's cloud account, to access their banking through their phone, to access their Google Maps, their GPS history, et cetera. With the cloud functionality that I mentioned these 5 agencies have, they advertise as a way to work around warrants, and you no longer need a warrant, you just need the phone or an image of the phone.
I understand hypothetically what could be done with the technology. All I'm substantiating is you've had multiple people here that have testified, and none of them have said any of these things. And they're, as you know, when you're at a committee, whether you're sworn in or not, you're beheld to tell the truth under penalty of perjury. Or penalty of contempt of parliament. So nobody has testified to this. In fact, I think I'm just going to read what the CBSA said. Devices examined by the CBSA's digital forensic teams have been seized pursuant to specific court orders, such as search warrants or judicial authorizations issued to CBSA investigators. The data extracted from seized digital devices is processed only within the CBSA's own digital forensic laboratories and is provided only to those having lawful authority to access that data. I'd also like to clarify that spyware is typically defined as software installed in a device for the purposes of covertly intercepting, monitoring, and/or gathering a user's activities or data. I want to assure the committee and the Canadian public that digital forensic tools utilized by the CBSA's investigators are not spyware. We use digital forensic hardware and software to unlock and decrypt seized digital devices as an important tool in our efforts to enforce border-related legislation to protect Canadians. You have no basis to dispute any of the things that are said there, do you?
No, I don't.
Okay. See, all I want to establish is that I understand, right? This is really scary technology to a lot of people. And if it were used improperly, and we need to have safeguards to make sure it's not used improperly, there are a lot of bad things that can happen. But we have no evidence of that, and I don't want to scare Canadians into believing that that's actually happening.
At the same time, we don't have necessarily any oversight or transparency on the use of these tools going back almost 40 years now.
Well, I mean, that's your contention. I would say that we actually do have oversight based on the heads of the departments and people that are, again, under pretty strong ethical rules to comply. But I get what you're saying, that of course there's fears, and we have to make sure, and our job as a committee is to make recommendations to make sure that our policies and regulations are in place to mitigate any concerns that may exist. Do I have any time, Mr. Chair?
Point of order. I'm wondering if Mr. Housefather wishes to become a witness, and we can cross-examine him, because he's certainly giving evidence that this.
That's not.
He's giving evidence that this committee is not heard through witnesses.
We're stopping this.
I actually just read from the witness's testimony.
Hold on, Mr. Housefather. That's not a point of order, Mr. Brock.
Thank you, Chair, and good morning, Professor. I want to focus not squarely on the device itself and the software attached to it, the focus really of this committee hearing, but rather the broader issue of privacy. You spoke in general terms about this being a fundamental human right, has been a fundamental human right in Canada since 1977. I'd like to get your expert opinion, sir, on this disastrous ArriveCAN app that has just been revealed to be an abuse of taxpayer dollars of $60 million plus. Now, if you can think back to the time where the ArriveCAN app was heavily promoted by this government, that it's the way to go in terms of dealing with the COVID, trying to protect Canadians, et cetera. But there's a portion in the preamble when you sign up for the ArriveCAN that I'd like your opinion on. And the title is called How Your Information is Used and Disclosed. Personal information may be disclosed to contractors working for the Public Health Agency of Canada and Service Canada, as well as to the following entities: other government institutions, as well as provincial, territorial, municipal governments, or international health organizations, as well as their institutions for these purposes. Personal information may also be used for program evaluation. In other limited and specific circumstances, personal information may be used and or disclosed without consent in accordance with Section 7 and subsection 8 sub 2 of the Privacy Act. Every Canadian, tens of millions of Canadians who were forced by this Trudeau government to sign up for this ArriveCAN app,
Point of order, Chair.
it looks like, had their
Chair.
personal information wildly...
Hold on, Mr. Brock. I have a point of order, and go ahead, Ms. Khalid.
Thanks, Chair. I'm just questioning the relevance of Mr. Brock's questioning. I'm sure the witness is not called for the line of questioning that Mr. Brock has delved down.
Just hang on a second. In every circumstance that a point of order is made, I am consistent in my ruling. I did it with Mr. Housefather, and I'm doing it again with Mr. Brock. It's his time. We've got a subject matter expert on privacy that's before us here. I'm going to allow Mr. Brock to continue. He has the floor, and I'm sure he's going to bring this to where it needs to go. Mr. Brock? Ms. Khalid, we can beat a dead horse on this. I've been chair of this committee now for almost a year and a half, and my rulings have been consistent in every circumstance for every member that sits around this table. Mr. Brock, you have 3 minutes and 2 seconds. Go ahead.
You heard the exchange. Some Liberal members don't care about privacy. Conservatives certainly do.
I object to
I'd
that.
like to get your
Mr.
opinion.
Brock, it's a matter of opinion, Mr. Brock.
Chair, I wasn't going to say it. I will say it now. Mr. Brock started his questioning by saying that he is going to be asking a question that is not relevant to the topic at hand today.
I'm not sure I heard him say that, but I can certainly check back. But Mr. Brock, you have the floor. 2 minutes and 50 seconds.
Privacy. So, Mr. Light, Professor Light, can I get your opinion on what I just read out to you? Is that a danger? Was that a danger?
I just want to preface this by stating I am a member of no political party, and I come to this believing that privacy is a completely nonpartisan issue.
Yes.
We're talking about a human right. It's
Yes.
not negotiable. It's not debatable.
Yes.
I think that the preamble that you read is really fascinating because to me it speaks to, if you remember, to Bill C-51, which was a Harper government law, created a brand new level of data sharing between government agencies. And this preamble sort of lays out how that happens. It shows you how this information flows between agencies and how it's become a quite normal thing to do. I think that dates back a very long time. That's not a new thing. It's probably been going on since before the Harper years, but I think it's something that maybe was informal and now has become quite formalized. It does scare me. As somebody who used ArriveCan when it came out because I found it easier, or I wasn't provided with paper on a plane to fill out. I think that our technologies at airports, at borders, are quite invasive. They're also quite invasive everywhere in the world. I've been to airports in Europe where I can't go to get a connection without having my face and my hand scanned. So I think our levels of invasion are not necessarily at that high level here, but I think that it's problematic.
Particularly with the phrase "without consent," I think is extremely problematic. Would you agree with that?
Yeah, and I think that the position that it puts a traveler in, for instance, just as in the case of using mobile forensic devices within agencies for administrative purposes, you're in a position where you can't necessarily consent, where there's a power imbalance, and so you're doing something because
one can only surmise what type of information that is in the possession right now of the government of Canada, not used for purposes to protect that individual from COVID. Now, another issue I want to discuss. How much time do I have, Chair?
You have 45 seconds.
45 seconds.
Mr. Brock.
You were aware
that
that
to the timelines.
Thank you. You're aware the Auditor General released a report. She talked about cybersecurity leaks, the individuals, the contractors not having proper security clearance. How do you weigh that, sir, in terms of an opinion?
I can't say I haven't read it closely.
You have not?
Nope.
Okay, the phrase is, the agency told us that the resources did not have access to travelers' personal information. Having resources that were not security cleared exposed the agency to an increased risk of security breaches. This is in relation to the CBSA, giving contractors without security clearance the authority to gain information on travelers. What's your opinion on that, sir?
I would see that as problematic.
Okay.
Problematic. Thank you.
Thank you, Mr. Brock. Ms. Khalid, go ahead.
To be clear, employees' personal phones are not impacted by what we are talking about here today. It is specifically government-owned devices, yes?
I think this committee has spoken about a number of different possible uses. So there are uses in administrative cases for internal evaluation of government-owned phones, and then there are organizations, most of the organizations that you've had come testify to you have spoken about the use on devices of non-employees, DFO, Transportation Safety Board, CBSA, the RCMP. They use this on non-employees as well.
I'm not sure if that was my take on the testimony that we heard, but just on that, the relationship between warrants and hypotheticals, as in what could be done or what is possible versus what is actually done. Do you think that there's a break in public trust? Clearly, you have mistrust in how departments are operating these devices with their employees. How do you think we can work to build better trust so that you and others don't think that that what could be done is not actually being done?
So for me, as a researcher, I want clear evidence. And so in the process of preparing ATIPs for these agencies, for their internal policies, for their use logs, show me what you use these things for, show me why you use them, show me what policies exist, what policies don't, what laws exist, and what laws don't.
And lastly, I just want to go through what your definitions were with respect to spyware and digital forensic software. Now, you had said that they're basically one and the same, and that's not what we've heard in testimony from other witnesses. Can you clarify your position on that, please?
Their capabilities are somewhat the same. So spyware, you have applications that are surreptitiously installed on people's phones in order to spy on them in real time. Mobile forensic devices give you the ability to access the same granularity of data after the fact. So they're not the same thing at all, but they provide the same, essentially, access to data that you would not have otherwise without having to get a warrant to the degree that you would need to get a warrant to access each connection to a cloud service provider, for instance.
And you don't have evidence to support that this is actually what is being done in these departments for now?
I don't, because, no, but I do have evidence that they have purchased the technology to do it. And for me, why would you purchase technology to be able to access these things if you were not planning to do it? These are separate technologies. All the mobile forensic devices are various softwares and hardware pieces that can be bought piecemeal. And so the technology with the capability of doing this has been recently purchased. There are licenses that are active through the middle of the summer of 2024.
Thank you, Mr. Light. Thank you, Ms. Khalid.